You want to know why domestic terrorists are operating on American soil known to be destroying human beings' lives and being promoted for it? This must come to an end, my friends. And to set the mood for these transcripts, I believe in the most proper way, allow me to play a little clip that was sent to me from Shane, a beloved brother who sat through these court cases with me. He is a witness to all these wicked and evil acts that were taking place on American soil against we the people, and to show you the way that American justice should have operated in my case, which would have kept all this from ever coming to transpire in the courts or any place else had they merely came to the same conclusion they do right here.
1130 Arroyo Vista, is there a problem? Well, I mean, is that where we are?
There were house numbers on that mailbox, plain as day, 1130.
I don't see any. Do you, Deputy? No.
Well, somebody messed with them. This is 1130 Arroyo Vista.
This here's 1240 Arroyo Vista. It's always been 1240 Arroyo Vista.
1240.
1240.
My client says it's 1240. Mr. Acker's been living here for 30 years. I think he knows his own address.
Sir, you got something with an address on it? 1240 Arroyo Vista.
Anybody can print out something like that. You got an order signed by a judge.
You know, we could get a surveyor up here this afternoon. He'll clear everything up.
That'd lose us a full day.
Listen, officer, before you go forcing an elderly veteran from his home and take everything he's got, demolish a half-century of hard work, wouldn't you like to know you got the right place?
I have to make a call.
So let's get right into the reporter's record, volume 1 of 1 volume, trial court cause number 23075B, the city of Abilene, Texas, in the district court. And you can see all up here, these little dealies, all the stuff here should be moved over to the side. So the way it reads is the city of Abilene, Texas, a municipal corporation, and Sharon E. Hick, T. Daniel Santee, Megan R. Santee, Patricia Trish Aldridge, Carolyn Foster, Carolyn Edmondson, Kimberly Barr, and Rosita Priest as individuals and employees of the city of Abilene, Texas, and Richard Sullivan individually. These are the plaintiffs that took your misappropriated tax dollars, filing this known fraud into a district court of Texas, wherein the judge, being a co-conspirator, allowed most of what he could for the plaintiff, while denying justice, giving America a black eye, buying through it obstruction of justice, aggravated perjuries, fraudulently altered documents, the fraud itself that was filed into the court. The cause of action was over 600 Virgil, my friends, and 600 Virgil. Please look up 600 Virgil, Abilene, Texas, and you'll see it's an address that does not exist, but the acting judge, the wicked man that sat as a judge in the 104th District Court of Taylor County, Texas, protected these plaintiffs to the point where the most simple aspect of law is that the plaintiffs are to prove their cause of action, but this judge was having none of that because there were 10 plaintiffs, actually more, whose reputations, their careers, their freedom, because they should be in prison, but they're out there being promoted for doing things as they have done to me. And if the evil is not punished and the guilty are acquitted or not held accountable, it gives excitement to the delinquents to further in these unlawful actions, which you'll see in this testimony that is about to be given, wherein I show more criminal act by public servants than most people on earth today have ever committed by their own selves during their lifetime. But these plaintiffs verse me, Al-Yahnai Fountain Hawkins, this should be AKA Alan Douglas Fountain, and then they also were suing Janice Lyons, the county clerk of Taylor County, Texas, in her official capacity, and we both were defendants. And the reason they were suing Janice Lyons is Janice Lyons, being the county clerk of Taylor County, is where I filed a bill, as you may have seen or will see in the next video, depending on which video you see first, wherein my billing was over $1 billion. And I know it may raise eyebrows, my friends, but it's the very same type of billing that Willie Nelson went through with the IRS. It's the same principle. It's the same practice, and not only the city of Abilene and the plaintiffs therein, but also the state of Texas has defaulted. And through conspiracies, my billions and the state of Texas are judicially oppressed. They have been taken from me. They've been held hostage in a hostile court that is a foreign court and has nothing to do with America or the United States of America's corporation or the laws, the codes, the regulations, and or etc. set forth therein. And this nest of domestic vipers and domestic terrorists must be abolished. And to me, remedy, being paid for what has been stolen and kept stolen for so many years. Now, the title or the subject matter of this filing was a motion to challenge jurisdiction and objection to partiality shown to known felons. Yes, I filed this in the courts, my friends, but I know as a whistleblower that should only be called an upright individual living on American soil that there is no oversight going on, my friends. I had written to the judicial committees. I written to the Texas Bar. I wrote senators and congressmen. I wrote all the way to the President of the United States, and these known felons are given partiality. They're protected. And I've got all the prima facie evidence in the whole wide world to prove it. Share this with everybody you know. It says here, on the 28th day of August 2009, the following proceedings came on to be heard. Now, this should never have been heard in his courtroom in the 104th District Court. This matter is a challenge to jurisdiction that must be resolved in a higher court than the one asserting its jurisdiction that it did not have to show partiality to known felons. So it came to be heard in the above styled and numbered cause before the Honorable Lee Hamilton, judge presiding, held in Abilene, Taylor County, Texas. Proceedings reported by machine shorthand by Julia Campbell, RMR, 104th District Court. Phone number is such. Then there were appearances. This Mr. Stanley Smith, who took the place of, I believe it was Sharon Hick, after I proved she had given aggravated perjury on the witness stand, and the judge let her get up, wherein she promptly resigned from the city of Abilene's legal department or office, and she fled because she knew what was coming. So Mr. Stanley Smith took her place. He was the assistant city attorney, Post Office Box 60, Abilene, Texas, 79604. Please give him a call. If he's still there, he may have been promoted to being a prosecuting attorney someplace else to destroy innocent people's lives. I don't know. But these people need to be held accountable. And as your Ronald McDonald, the President of the United States of America's corporation, that will be my primary goal, is to make your lives better by going after those who've been giving false reports, fraudulent statements, and all these other things to destroy the lives of human beings. I don't know what the LE there is or the SBOT number 0791694 is, but it says for the respondent, Mr. Al-Yahnai Hawkins, Pro Se Movement, 9486 County Road 254. Please, my friends, look up this address. You'll see that there was never a fire reported. They burned me out after they had kidnapped me and tortured me. But on or around the 7th day, they burnt down my church, my domicile, and my vehicle that was located at 9486 County Road 254. They saw who burned it down. They were known, they were reported, but my friends, in this here United States of America, when it comes to a regular human being's life such as my own, they did not even conduct an investigation. Please look up 9486 County Road 254, Clyde, Texas 79510, and you'll see there's no information. It never made the news, though the arsonists were known. So further and down, it shows Julie Campbell's name again. Then it gets into Volume 1, Motion to Challenge Jurisdiction and Objection to Partiality Shown Known Felons. It shows the different pages, as this is like the index. Let's jump down to the proceedings. Here on what shows page 1. It says Proceedings, August 28, 2009. Yes, these things been going going on since 2009. I've been living as a disabled pauper since 1994 after I got injured on a job that I should have never had if these wicked and evil people did not steal from me and did not rob and plunder from me what was not theirs, nor they had no jurisdiction to take a thing. Motion to challenge jurisdiction and objection to partiality shown on felons at 3:05 p.m. Open court, counsel, and Mr. Hawkins present. Then the Dishonorable Lee Hamilton, the court says, okay, good afternoon, please be seated. This is cause number 23075B. The matter before the court this afternoon is a motion to challenge jurisdiction and objection to partiality shown to known felons. This pleading was filed on July 10th and was signed by Al-Yahnai, Hawkins, and Howe says the movement. Are you ready, Mr. Hawkins? I state, yes, sir. The wicked Lee Hamilton? Okay. And Howe says the city of Abilene. Mr. Smith says, City of Abilene is ready, Your Honor. The wicked Lee Hamilton says, and Mr. Hawkins, you may proceed. So I say, I hope you don't mind if I just stay seated, sir. The Lee Hamilton says, that would be fine. So I says, all right, sir, did you read my motion? And did you read the memorandum to the motion that I filed? The court says, I read the motion, and the motion is 4 pages long. And you've referred to a memorandum, shows Julie R. Campbell's information again. Page 2, Mr. Hawkins, which is me, and I say, yes, sir, which was filed on August 5th, that goes with this motion. I didn't see no sense filing a memorandum with it at the time, Your Honor, because I figured that if you weren't going to hear it, there was no sense me wasting my time with typing the paper and all that. So the judge says, you filed a document? You call it a memorandum? And I says, yes, sir. The court, okay, you filed it on August 5th? I answer, yes, memorandum and judicial notice. Court says, well, I see a document which reads affidavit of truth, a true bill, and a public notice that was filed on August 5th. And I says, yes, this was all this here, Your Honor. These exhibits were filed with it or attached to this memorandum. So the judge says, bailiff, can you assist me, please? Why don't you? Do you have a copy of what you're referring to, Mr. Hawkins? And I played their shenanigans long enough. I told him, I says, this is the only copy I have with me, sir, because I did file it. Court says, let me just look at it and try and see if I've got that document in the court filing. And then the bailiff handed a document to the judge that I gave to the bailiff, and the bailiff gave it back to me. And then the court says, Mr. Hawkins, I have read your motion to challenge jurisdiction, and I did not see this memorandum of judicial notice. So I said, it should have been right in front of the affidavit of truth, a true bill and a public notice. And the court says, yeah, it's not in front of that. Those documents, it's behind. And so I said, could we maybe get a copy of this made, sir, and we can get it to you? Court says, no, it's in the court file. So you can see these things are in the court file, my friend. I further saying, oh, okay. Judge says, yeah, it's the court's file, but I just haven't seen it. Did you give a copy of this memorandum and judicial notice to the city of Abilene? Well, of course I did. So I answered, yes, sir. And the court says, oh, okay. Said I filed everything with everybody that's involved. So the court said, let me take a moment and look at this. And I said, all right. So there was a recess from 3:08 p.m. to 3:21 p.m. Oh, and I don't know how many pages there was, but he had to read pretty fast to get through it. So then at 3:21 p.m., so let's just jump right back into page 4 here. It says open court, counsel, Mr. Hawkins present. The judge came back at 3:21 p.m. and the judge says, thank you. Please be seated. Okay, I have read the memorandum and judicial notice, and Mr. Hawkins, you may proceed. Now please pay particular attention, my friends. You may not know much about law, but I assure you what I'm going to bring out that was brought out in front of many people sitting in that court. And please understand that during a court proceeding, if there are facts being stated and the plaintiffs are there and they do not object, then they agree to what is being said. So what I'm saying, if it's not objected to at the time I'm saying it, my friends, or shortly after, then you know everything that I've stated is a fact in this case. So I start reading. And please note that I'm using this time knowing that this motion cannot be heard by that judge in his courtroom since it's his jurisdiction being challenged. But I know enough about that I'm going to put as much as I can on the record and in the record until he shuts me up. Because these are transcripts and can be used as prima facie evidence in any investigation or any court. So the judge told me to proceed, and I say, all right, sir. I'd first like to start out with a little background about things concerning the case, what brought this case about. In 1989, February 27th, the middle of winter, the city of Abilene came to my property with bulldozers and a demolition order for the wrong address. And instead of doing what they did in that little video clip of Saul there that I used only for proving a point of how human beings should conduct business toward each other, especially when it's demolishing of their entire livelihoods on the line, and I had a water bill for 700 Virgil in my pocket with 600 Virgil on the demolition order. So he didn't pay attention because what he was going to do was for 600 Virgil and not 700, but there never was a 600 Virgil, my friends. But Richard came to the property with bulldozers and a demolition order for the wrong address. They ordered my pregnant wife and myself off our property. They bulldozed everything we owned. 2 brand new houses. They left us in the winter, no place to go. I had just quit my business or my job to take care of my business that they demolished and removed totally. They didn't have any search warrant. They didn't have any seizure warrants. They took everything we owned and put us in the snow. Since then, I was told by the city in one of their papers that if I went against what they were saying, I could go ahead and get go to an appellate court. So what I do is I file in the district court, and they laughed it out because there was no court before that. So they basically gave me false information on how to conduct legal business. And ever since that time, Your Honor, I've been filing different contracts with them, trying to make them pay for what they had demolished without a reason, without a cause. It wasn't even condemned. If it was condemned and they bulldozed our house, then it's an obligation of the city to put us up into a place for where we could live up to 5 years if we were living in a condemned structure. There was nothing condemned, so I fell through the cracks on that. My wife and I ended up living out of an abandoned school bus, scared the Child Protective Services was going to come down and take our unborn child once it was born because we had nothing for them to live in. We filed different contracts to where I was telling them that what they owed me for the laws that they broke against me and everything else, they never answered. So, under Texas Rules of Civil or Texas Civil Practice and Remedies Code, Chapter 18, it does state that for the necessity of cost or whatever, if they don't answer within 14 days and they admit to it and they do owe it. According to the statutes of Texas, it's a law that they have to abide by. I also had default judgments placed upon it, certificate of default, and the defendants filed it into the record. So it's in the record, okay? Now, what had transpired after that was 10 plaintiffs of the city of Abilene: Sharon E. Hicks, T. Daniel Santee, Megan R. Santee, Patricia Aldridge, Carolyn Foster, Carolyn Sick Edmondson, Kimberly Barr, Rosita Priest, as individuals and employees, public servants of the city of Abilene, Texas, and Richard Sullivan individually. Now, Richard Sullivan, the reason he was listed was because I had stated in a Board of Public Standards Committee meeting that he came on my property and burned down my house, and it upset him greatly. He's the one that signed the demolition order to have my property removed from me because it upset him. They found him out. Back in the early 70s or latter 70s, early 80s, the city had on the docket what they wanted to do was build a second Lytle Shores. Lytle Shores 2, using man-made lake paid by city funds that they would later put high-dollar houses around, selling it off so that nobody could have access to the lakes that their taxpayer dollars had bought. So they burned my house down instead of talking to me. The neighbors around the area area they talked to about buying their property. But my piece of property landlocked 26 acres. Now that word there says lot, but it should have been locked, as in when you lock your door. I had 26 acres landlocked by my property. Instead of them making any deals with me, this is the way they dealt with me. So I filed my contracts with them, the billings that I had sent in, and what they did instead was got together. And as it shows in what I had sent you, it was by Carolyn Foster. It's dated July 26, 2003, and she emphatically states, as I understand your allegations in these documents, you are alleging that there was a violation of due process arising out of the city demolition of your buildings on your property located in the 700 block of Virgil. Now please keep in mind that date, Your Honor. It's July 21st, 2003. Right after they had bulldozed my property, which took place on February 27, 1989, I went down and Exhibit E, that's with that packet, okay, the packet that I filed with this motion to challenge the jurisdiction to show partiality toward known felons, I placed it again, my friends. This is a few times I've placed that same document into the record with the judge ignoring it. It says right after they bulldozed my property, I went down and Exhibit E is what that packet, March 17, 1989, I went down and saw Mindy Manson. I was all in preparation for this. Now I'm talking about the very day I was standing in the court wherein these transcripts came from. I knew it was going to come, since even before they burned me out. I was shown these things long ago, and I was preparing, and this was all in preparation for this day. It's been a 20-year preparation for this day. And she says, to whom it may concern, East Lot so-and-so, the above referenced tract of land generally located in the what? 700 block of Virgil. So you got Mindy Manson here saying 700 block of Virgil, and that was on March 17, 1989. That I owned 700 Virgil. You also have Carolyn Foster that did sign this, okay? The letter dated July 21st, 2003, saying she understood it was over the 700 block of Virgil, okay? So what they did was then they got together and they conspired. It's a big conspiracy where you've got 10 plaintiffs all wanting to use misappropriated public funds, which I already showed, and they decided they wanted to launch a lawsuit. Exhibit I, which was in that packet as well that I had given, Exhibit I shows where Sharon Hicks had talked to the city reporters, and she had mentioned in here, it says, this dispute, and this also is July 26, 2003. Her letter was dated 5 days prior to that, July 21st, 2003. And this also is July 26, 2003. This was July 21st. This newspaper article was written on the 26th. And she states here, even though it says 700 Virgil, where she signed and certified it, because her signature, according to the Texas Rules of Civil Procedure, Rule 13 states that a signature on any document that's filed into a proceeding is a certificate that they have done due diligent research and everything else, and that what they've put there is truth. You yourself, Your Honor, you're supposed to take it as if it is truth and filed in good faith. But it wasn't. That's why we're here today. Anyway, in the newspaper article, it says the dispute stems from the 1989 demolition of Fountain's house at 600 Virgil Street. In 1989, Mindy Manson said 700. Just 3 days prior or so, 5 days prior, July 21st, Carolyn Foster, the assistant city attorney, said she understood it was over 700 Virgil. Now Miss Hicks gets in the paper and says 600 Virgil, and also makes a statement that says most of the city's vehicles, police cars, Hicks said, would be difficult to steal. So now I'm wanting to steal police cars after they bulldoze my house unlawfully. I came in your court, Your Honor, and I spoke to you, and I told you you, I says, Your Honor. And I even made an affidavit and I put it on eBay. But they kicked it off eBay because they said I was trying to bring criminal activities to eBay because I had stated that you could blow my brains out with a bailiff's gun if you or, it says, and then I pulled the document out that was attached to the motion to challenge jurisdiction. I show it to everyone and I start reading, and I say, it says, hear ye, hear ye, hear ye. If any flesh and blood man or woman living on planet Earth, and the court interrupt me. John Weeks says, excuse me, Mr. Hawkins, when anyone is reading a document out loud, they have a tendency to read faster than they would normally speak. So I says, okay, Your Honor. And the court says, and the court reporter is over here trying to take down everything. So when you're reading a document, try to read at a conversational speed, okay? And I says, all right, sir, I apologize. And the wickedly Hamilton presiding says to me, no problem. And please understood that what I'm about to read is an affidavit that I created, I signed, I had notarized, I hung it in the lobby. It was hung in the lobby of the courthouse. Well, I can't remember exactly how long it was, but the time provided that it needed to be, it hang there for, and I did file it with the county clerk, who was named as a defendant in this matter as well, because they wanted to have this expunged from the record as well as the billings that I had made and filed in the county record. But the problem is I can't go to the county records, obtain my copy of the bill and go to any other court, because then they could claim double jeopardy because my defaulted billings against the city and many wicked and evil men and women by obstruction of justice and or etc. is still sitting in the record, depriving me of what is judicially mine. So I started reading that affidavit again, and I said, hear ye, hear ye, hear ye. If any flesh and blood man or woman living on planet Earth or any beings in the heavens can prove that I, Al-Yahnai Fountain Hawkins, aka Alan Douglas Fountain, ever owned 600 Virgil Street, Abilene, Texas, or that I have ever made any claim to any damages that arose from any demolition of that 600 Virgil Street on or about February 27, 1989, as is a fraudulently filed cause of action before the court, a known fraud that your tax dollars paid for, then the Honorable Judge of the 104th District Court, Taylor County, Texas, may take the bailiff's gun and me out to the driveway and blow my brains out across the parking lot of the Taylor County Courthouse located on Oak Street, Abilene, Texas. Now, I stated that way back then, Your Honor, because what their cause of action was all things that arose over 600 Virgil. And I stood before you, and I've written affidavits. I put them on eBay. Nobody's listened to me. I never owned 600 Virgil. Now, a little digression, in that affidavit, I also said I would admit guilt to whatever unsolved crime has taken place in the state of Texas for the last 100 years. But yet in the courts of Texas, they don't need to give you a jury, though bought and paid for. But then again, do you think any jury would find the defendants worthy of acquiring each $10,000, in excess of $10,000 from me with exemplary damages, and to put me into prison for 10 years over this known fraud that the judge is protecting? I can understand completely why they wouldn't allow a jury, but this is America, and the justice system's supposed to be of justice. I stood before you. I've written affidavits. I put them on eBay. Nobody's listened to me. I never owned 600 Virgil. So when I stood in the court, and I said this to you, and they prepared, what you allowed them to do, Your Honor, was to amend the pleadings, their original complaint wherein they thought, and I knew the last time I was here, Your Honor, but I didn't want to bring it up because I didn't want the claim dismissed. I knew it was going to come about, but what they did when they first started this is they got 10 affidavits, because you have to have affidavits in order to go with the original complaint. Now I got Carolyn Foster on July 21st, 2003, saying she understands that it arose over 700 Virgil. You got the City of Abilene, 1989, Mindy Manson, saying I own 700 Virgil, 10 affidavits filed. This was an affidavit of David M. Wright. He says right here, I'm familiar with the allegations made by Al-Yahnai Fountain Hawkins, formerly known as Alan Douglas Fountain, alleging that the City of Abilene is indebted to him for over $1 billion arising out of the demolition of property located in the 600 block. I never said that, my friends. This is their fraud they created. It's their Pinocchio. But he's claiming it arose out of a demolition on property located in the 600 block of Virgil. Again, my friends, please look up the information about 600 block of Virgil and you'll see it never existed. They could not have demolished anything on a property that was imagined. It doesn't exist. Now, this was notarized, Your Honor. This is notarized. This man, under oath, after already understanding the 21st of July, 2003, that it was 700 Virgil, and that it was dated July 23rd, 2003. Now, just a couple months later, the second day of September 2003, you got Mr. Wright saying it's over 600 Virgil? Why? There's no way to defend everything I brought before you, Your Honor. You dismissed because it had nothing to do with the cause of action. I brought you a water bill for 700 Virgil. I brought you an electric bill for 700 Virgil. You kicked it out because it had nothing to do with this fraud that they were bringing in. Now, that was David Wright. You have Sharon E. Hicks, the head city attorney, stating right here in big block here, it says property located in 600 block of Virgil. Now, why did she say that? Because 5 days after she went ahead and had this letter sent by her assistant, Sharon Hicks, puts in the newspaper 600 Virgil to start this fraud, a thing I couldn't defend on. So you've got Sharon E. Hicks also, Your Honor, that's signed. We've got T. Daniel Santee II, which I believe is now the head city attorney, officially he's a public servant, and he should be held at higher standards than this. For these people to come against me in such a way, Your Honor, and your court to allow it, it's totally unacceptable. Especially when it says right here with T. Daniel Santee 600 block of Virgil. Then you got Megan R. Santee 600 block of Virgil. All notarized. They signed under oath, Your Honor, that this was true. You had no idea. You had to believe these people. You got what, 10 plaintiffs against me? Most of them were city attorneys or the help in the office. We got the entity, City of Abilene, can't breathe or walk or anything, but it's also here, and that's where Mr. Wright signed for it. Now we got Patricia Aldridge, 600 block Virgil. Now why were they doing this? They used misappropriated funds to file this. It wasn't even their own money. They used your tax dollars and his and hers and mine and these war vets and everybody else. You know, I'm pointing around the whole courtroom. I'm using some dramatic. Furthering, I stated, they took their tax dollars and they bulldozed my house first because, you know, Mr. Sullivan was a little upset that I told him he burnt my house down, but he never denied it. And you notice, my friends, there's not one objection stated in any of this because everything I'm stating is 100% factual. But as long as they ignore me, they could tie it up in the court, what is rightfully mine, and to keep these plaintiffs out of prison where they all need to be. Furthering with line 8 here, it says, and then, like Carolyn Foster said, now this is a real clincher, Your Honor, July 21st, 2003, she signed this on the 3rd day of September 2003. What made her change her mind, Your Honor? When she said she understood my problems were over right here, 700 block of Virgil, but in her affidavit, Your Honor, it says 600 block of Virgil. Then we got Carolyn Edmondson, Oh, by the way, Carolyn Foster, after we had her on the witness stand and I showed that she committed aggravated perjury in your court, and I asked the bailiff to take her out and put her in jail. And I asked you to have your bailiff do it, and we all stood around like, And then we got moved on to something else. Well, right after that, Your Honor, she ended up resigning and fleeing because she knew what was coming. And we got Carolyn Sick Edmondson, 600 block of Virgil. We got Kimberly Barr, which is also a notary protest or notary public. And she actually did notary work in some of these things because they were conspiring together to each make in excess of $10,000 or more from me because they filed this fraud using misappropriated public funds, your tax dollars and mine. Kimberly Barr states 600 block of Virgil. I mean, look at all these high officials, all after a little old guy like me. I had to come in here pro se because there ain't an attorney that would touch this. We got Rosita Priest, 600 block of Virgil. Richard Sullivan, 600 block of Virgil. 10 affidavits, Your Honor, that were used in this cause of action. They thought they got away with it because, I'm sorry, they thought they got away with it because the court was very lenient. The court wouldn't make them or compel them to bring forth any evidence whatsoever of 600 Virgil. So I had to wait. I had given public information notices that I wanted information specifically on 600 Virgil. Now, this was a letter that was written February 10th, 2004, showing, it says, I've been advised that you've been attempting to obtain information from Mike Sexton at the Abilene, Taylor County 911 District regarding 600 Virgil Street. Your request appears to be related to the pending lawsuit styled by the city of Abilene, and so on and so forth. Please be advised that due to the pending litigation, any request for any information from the city of Abilene regarding any matters related to the pending litigation must be made through the discovery process under Texas Rules of Civil Procedure. So I have been asking them during the litigation, hey, who owns 600 Virgil? I want to know the tax records. I want to see the deeds. I want to see a water bill, a utility bill. Show me 600 Virgil. They refused me. They even found out I was trying to get it through Mike Sexton, which is a county public servant, their city, and somehow they found out and they put a stop to my request. Now then, it was only a couple days later that they had answered interrogatories for me. That was on February 10th. This here is the 13th of February, 2004. We're talking 3 days later, they answered these interrogatories after they said I couldn't have any information from Mike Sexton because this is litigation. I got to get it through these other processes. So I filed for interrogatories. Furthering, I said. Now I asked them in the interrogatories, and this shows that it was, groundless and without foundation, and it was frivolous and brought with the intent to just hurt me. I asked my first question, what address is shown on the demolition order dated February 27, 1989, sent to Alan D. Fountain that was to be demolished? The city wrote in that interrogatory, objection. This is the plaintiff speaking back. Plaintiffs object to this interrogatory, or plaintiffs object to this interrogatory, and that is seeks information that is irrelevant to the cause of action before the court. I mean, seriously, my friends, do you see why a jury isn't allowed? If a jury was there, they'd certainly say, hey, we want to know what address was on the demolition order, and it should have been provided. That's why I had to do these other steps. Furthering, it says, now, that's what the whole cause of action was over, Your Honor, was 600 Virgil. That's why they brought this, because they knew they could push it through this court. I'd be taken down because I got no evidence. There's nothing I could do over 600 Virgil. It didn't even exist. I told you 1,000 times it was a fairy tale. I even told you, Your Honor, I says, What you're trying to do is resurrect Pinocchio. It don't work. It doesn't exist. You can't make Pinocchio come back to life. He never was to life to begin with. He's a wooden doll. And you're trying to make 600 Virgil come about. And then they said, is not reasonably calculated to lead to the discovery of admissible evidences as for purpose of harassing the plaintiffs. Additionally, the interrogatory seeks information that's equally available to defendant Hawkins. This letter came 3 days later, my friends, and the letter that I wrote Mike Sexton here that should have been equally available. But Mike Sexton says I can't have it because this matters in litigation. And I filed these interrogatories and they was answering them. And again, there's nothing I could do over 600 Virgil. It didn't exist. And furthering again, it says, and they said it is not reasonably calculated to lead to the discovery of admissible evidence and is for the purpose of harassing the plaintiffs. Additionally, the interrogatory seeks information that is equally available to defendant Huff. Furthering, I stated, I says, now, Your Honor, I just showed you on February 10th, they told me, oh, you can't have this information, it's during litigation. Answer the interrogatories here, Your Honor. And they're telling you, Your Honor, and the court, and the people of this state, they're saying additionally, the interrogatory seeks information that is equally available because I asked for it in the interrogatory. Now, they had to sign this under oath showing that these things were true and correct. That answer wasn't true. The letter right here shows it wasn't. My next question, not next, but it was question number 9, interrogatory number 9. Who was the owner of 600 Virgil Street, Abilene, Texas on February 27, 1989? First, they object to exceeding 25 questions, but then they state, additionally, plaintiffs object to this interrogatory and that it seeks information that is irrelevant to the cause of action before the court, is not reasonably calculated to lead to the discovery of admissible evidence, and is for the purpose of harassment. Now, this next sentence here should have a question mark right here instead of a period, because I stated it's like I'm harassing them because I want to know who owns 600 Virgil. They filed this cause under 600 Virgil. That's their cause of action, that I had complaint over 600 Virgil. They've got 10 affidavits they signed stating 600 Virgil after they stated they understood it was 700 Virgil that I owned. It shows a whole list of documents over 700 Virgil. All of these they filed in the record. And when they filed it in the record, you asked if I objected. I said, absolutely not, Your Honor. Please put it in. I insist that it all gets put in there because I know that it could be used for evidence today. And then it said, plaintiff further objects to this interrogatory and that it seeks information that is equally available to defendant Hawkins. You wouldn't help me, Your Honor. I told you and I showed you. So what I had to do was, after they filed a fraudulently filed lien or claim against me because they gave a proposed order of a final judgment, I billed them each about $1 billion, and I filed it in the records without them having a hearing on it or anything else. What they do is they change the proposed final judgment. They change it to incorporate the billing that I put against them to get rid of that billing, and I brought it before you. I filed it on December 14th. I think it was 2006, 2007, probably 2006, but it was filed December 14th. You called me in the very next day to have us come in for not a hearing, but just to listen to it. But then you did tell me you would hear it, and we never got around to it. So what I ended up doing was I went to the Attorney General of Texas, Greg Abbott. Actually, it was Shane that took me down down there. He said, I've had enough of this. And he pushed me into his truck, brought me to my house. We grabbed all my documents and we went out to Greg Abbott's office. Furthering, I say, I went down there to Austin. I says, sir, it wasn't quite him. It was Mr. Woodstone or Woodsmith or something like that. And I told him and I explained everything. I brought the whole record down. We spent a couple hours together and he said, I can't understand how that occurred, Mr. Hawk. I says, well, I don't either. I said, but something's got to be done. He says, yes. He says, it does. He says, what do you want us to do? And I said, all I'm asking afterwards, because they said they couldn't do anything judicially during our conversation, but I didn't need to bring it up in the court. So the fella says, what do you want us to do? And I said, all I'm asking you to do, sir, is to make the city of Abilene, since they think the litigation is done and over with, make them under penalty of law if they don't, because they've been denying me my right to public information for a long time. Tell them that they have to answer my questions concerning tax records, deeds, anything of that sort, utility bills, whatever. So he did. He wrote this letter to them. He said, hey, y'all better go ahead and answer this man. And I was showing them the letter. So what the city of Abilene did on May 23rd, 2007, after you and I did put a halt to all actions that were done in this court, because I did challenge your jurisdiction, Your Honor. And I'm sure that you do understand and realize, according to the laws, according to sound law, rules of court, everything else, that once jurisdiction is challenged, then everything freezes. I know that the plaintiff is going to be saying, well, the thing is, your plenary power was over. But no, Your Honor, I came in on December 14th before your plenary power was over, and I challenged your jurisdiction to sign a known fraud. So from that point until it was answered, plenary powers have been frozen. There's a stay on all of these things. It's as if the matter never went out of the court. But anyway, May 23rd, 2007, it says, Dear Mr. Hawkins, the city attorney's office has reviewed your request received May 10th, 2007. Now, that was way after my other request that they showed that concerning the guy at 911 addressing February 10th, 2004. Now, this is a letter May 23rd, 2007. This is 3 years later, Your Honor. So I've been trying to get this information the best way I could, because I could get no help from the court. They weren't going to give me anything. They all filed a fraud. They knew what they did. That's why I got them on the misappropriated public funds. They said, oh, Your Honor, well, hey, we don't want the $10,000 anymore. It looks like Mr. Hawkins won't be able to financially handle that anyway, so just do away with our misappropriated public funds and federal funds charges, because, well, we don't want the money anymore. And say they didn't want me in prison. They said, oh, Your Honor, well, hey, we don't want the $10,000 anymore. It looks like Mr. Hawkins won't be able to pay to financially handle that anyway, so we'd like to drop the financial part that we're going to make personal gains, to become wealthy over the fraud that we filed on Mr. Hawkins. Okay, so this is now May 23rd, 2007, and it says the office reviewed my request dated May 10th, 2007, and we will address the two issues that you have raised. Request number 1. All information provided in copy or by disclosure as to the location with access to records of all information pursuant to 600 Virgil Street, Abilene, Texas. Now get this, from the date it was initially addressed by 911 Taylor County Addressing, or whatever name of the company or whatever it is that does that, their response, please be advised that the city of Abilene does not have any information responsive to your request. They have no information about 600 Virgil Street, my friends. I'm showing the judge in the court that absolutely the cause of action, 600 Virgil Street, does not even exist by a department of the city of Abilene. They're admitting it don't exist dismissed, and yet the judge did not acquit me or release my bill, or to decree that my bill that they did default in is owed. And they tried to murder me in 2016, all stemming from these things. They said they had no information responsive to my request as to any information there. All information concerning 600 Street of Virgil. There's nothing there. And I furthered saying, that's why they didn't answer in this court, Your Honor, because they had no information about 600 Virgil, because it's a fairy tale. Just like I told you, I put my life on the line. I said, Your Honor, if you or anybody else can prove that I had anything to do with 600 Virgil, you can take me and that bailiff's gun down to the parking lot and blow my brains out for my due punishment. And I also told you in open court that I would admit to every sin, every breaking of any law that nobody answered for the last 100 years. I would take responsibility for that too. My request number 2, my request for Public Information Open Records Act pursuant, my second request herein is as follows. I request all information for the location of any titles, deeds, and or etc. And the response was, please be advised that the City of Abilene does not have any information responsive to my request. This here City of Abilene letterheaded. It took me 4 years to finally go to the Attorney General of Texas. I had to drive all the way out there to get this man to go ahead and tell these people, hey, look, litigation's over, guys. Even though it really wasn't, because I put in the motion to challenge jurisdiction, but they believed it was done. They believed they'd have no more problems from me, and they think that their conspiracies are waterproof, you know? Said you can't withhold this information anymore. You gotta give up your fraud. You got to let him see. So they wrote and said, hey, it's a fairy tale. They brought me into this court, Your Honor, using fraud, deceptions, false statements. We got 10 affidavits all signed after they claimed it was 700 Virgil. They understood it, but yet all them 10 affidavits each state emphatically that it's over 600 Virgil. I said the whole time, no, 700. If you're gonna judge me, then do it right. Yes, I put in these contracts for you people to pay me because you destroyed my life. You took my pregnant wife and threw them out in the middle of the winter, bulldozed our houses with a demolition order that didn't go for the property I owned. There wasn't anything condemned, and you're going to fight me? And you know the sad part, Your Honor, I told you, and I wrote you in several of my pleadings a maxim of law. It says, evil deeds ought not to remain unpunished, for impunity affords continual excitement to the delinquent. Well, this last December, Your Honor, in 2008, I bought a house. This last January, after I wrote them affidavits saying, hey, I own this thing, don't you come on my property without having a proper search warrant or proper seizure warrant. Don't you come on my property. You call me and I'll come down to talk to you. Now, this maxim of law, Your Honor, should control this court. I wrote it in the case many times because I kept being the one that they kept getting the judgments against me. They didn't even have to answer what the true property was because they were using misappropriated public funds to make personal and private gains, each over $10,000 with exemplary added to it, and you were allowing it because you didn't know. They weren't telling you the truth. They misled the court. They deceived this court. They deceived me. Well, I wasn't actually deceived. I'd like to retract that statement. They didn't deceive me one bit. I saw through it from the very moment that they filed this. They filed this and you gave me less than 48 hours after getting served this big old complaint to be in your court. And when I brought in my answer before you, Your Honor, well, you dismissed my answer. I didn't even have time to file it. I was up for 48 hours straight to be here in court to answer something that the Texas Rules of Civil Procedure say I got at least 10 days. But evil deeds ought not remain unpunished, for impunity affords continual excitement to the delinquent. And then the judge, the wicked Lee Hamilton, presiding, elected as a wicked district judge, interrupts and says, Mr. Hawkins, excuse me just a minute. Sir, I've reviewed your motion and I've reviewed the memorandum and judicial notice, and I've heard your argument that you're making. I understand your point. Can you finish up your presentation within a couple minutes here? Now, I'm sure some might say that that's a rush of judgment or whatever, but I actually got way more into this matter than I had first expected to do. And you could see that the judge understands the misappropriations of public funds. He understands that there was no making the plaintiffs prove their claim, their cause of action. He understood that my rights were stripped by a bunch of fraudsters, a bunch of domestic terrorists who create their own statutes, their own codes, their own laws, and then they bring them into the courts and they uphold these horrible crimes against we the people by public servants. That should never be. Have you looked up what a public servant is? And so, knowing that the judge is only going to give me a couple more minutes here, I decided I better start wrapping it up in slamming the plaintiffs as well as the judicial system itself, because these things, my friends, wouldn't take place in Russia. Putin would be upset over that, and I don't think it'd be allowed in China neither. I've seen where wicked businessmen that were harming people and such were actually put to death by China. Did you know people in China own cars? People own homes? Did you know people in China buy food and they cook their own meals? They wake up in the morning, they go to jobs. I heard the same thing goes on in Russia. I know things are different in America. America, you could wake up and find out, after you come home from work, that you haven't even got a house or anything left. And what I didn't mention in this transcript is they actually billed me for the unlawful demolition. They billed me to become homeless. And people want to know why people are homeless. Well, it's got to be that they want to be. No, it's got to be most people have closed their eyes. You know how many people I seen in jail that didn't even know why they were there? Had no court date or anything, and they've been there for weeks or months? Because every day they're in that jail, the private owners of the jail, the private owners of these prisons get paid. It's all a conspiracy, my friends. So furthering here, after the judge asked if I could, finish up the presentation in a couple minutes here, this was actually a testimony. And I said, yes, sir, I can. They came down in January after I bought it in December, and they bulldozed my home again without notice. 2 homes actually 3. I had 2 new homes in 89. I had just bought this other home, and they came down without notice because it excites the delinquency. They had to do this. Why? Because I was an informant. I was explaining to the city felonies that were going on in their land. And like it states, Your Honor, here in Chapter 32 of the Penal Code, under fraud, it states, false statement to obtain property. These are false statements. 600 Virgil, they claim. I said no, 700 Virgil. Now I proved it, and the city even said, okay, well, there is no 600 Virgil. It states, false statement to obtain property. Under B, it says a person commits an offense if he intentionally or knowingly makes a materially false, misleading written statement to obtain property or credit for himself or another. And then the penalty for that, Your Honor, under 7. A felony of the first degree if the value of the property or the amount of the credit is $200,000 or more. I got messed out of billions because of the fraudulently filed lien or claim that they placed in here, Your Honor. We're not talking 1 felony of the first degree. We're talking, Your Honor, if you take a look at the styling of this matter, we're talking 10 felonies for just 1 count. And we're allowing these known felons to be walking among us, public servants, to continue in this stuff? I'm going to have to bring this other suit, where they bulldozed my house again, without any notice again. And what kind of rigmarole are we going to go through there? They had no warrants. They had no, for search or seizure. This shenanigans has got to stop, Your Honor, and you've got the power. In fact, it's been put in your hands because you're sitting up there on that bench. You are the one that's supposed to look at the law, recognize the law, and by my just stating this one thing under fraud, it's a proven fact that it's a fraud when they sign their signature to 10 affidavits, actually 11 because the city was one, but they all stated 600 Virgil. And you heard this matter. And I was raked over the coals. I lost all kinds of money. I got 7 children. I had to answer these things. I've been damaged. I got friends and family that will tell you that I don't hardly ever sleep anymore because I never know who's going to come in the middle of the night or anything else after the treatment that I've received in this court. You've got the power to strike these things. You've got the power to reverse these things, and I'm asking you to do so, Your Honor, and also pay me the damages and to allow me to have that which was contract and put into this file that they tried to fraudulently remove by your never hearing about it. So the judge interrupts me, says, "Oh, thank you, Mr. Hawkins. Does the city ever respond?" And please understand in here, if you've seen what was written, you'll understand that this Mr. Smith here, who took the place of those that kept fleeing, he comes out with a bunch of stuff. I don't even know what he's talking about, and I do object to it, as you'll see. Mr. Smith says, "Briefly, Your Honor, there was a final judgment signed by this court and filed with the clerk on November 28, 2006. Now, my friends, that final judgment, I was giving a proposed final judgment. And I said, okay, the final judgment you propose is fine with me. So then what Mr. Smith did was, him and his department, the other plaintiffs and conspirators in this matter, they completely changed. They fraudulently altered the proposed judgment that the judge said would sign if I didn't object. Well, they gave him a completely different judgment, and he signed it, as any faithful conspirator would. And he's bringing up that proposed final judgment, then final judgment, that I filed a separate challenge to jurisdiction over. Furthering here, Mr. Smith saying, it's my understanding that there was no appeal taken from that final judgment, Your Honor. I hear Mr. Hawkins stating that he filed some sort of record or some sort of document after the final judgment, Your Honor. And then he's filed this motion to challenge jurisdiction in July of 2009. Some 2.5 years later, after the final judgment. Digressing quickly, just do a little bit of research about a challenge to jurisdiction. You'll see things all over the place that assure Americans that we're living in the right place, because it shows subject matter jurisdiction can be challenged at any time, and it is not subject to the 30-day time limit required by anything, my friends. If your great-great-grandfather was wrongly done because of a lack of jurisdiction, you as his relative should be able to file, even though old granddad's been dead for 60 years, you can still file against the jurisdiction to clear your great-granddaddy's name. Oh, and one other thing about this final judgment that was signed here by Mr. Smith, in a timely manner, they're supposed to mail that to all parties, but Mr. Smith failed to do so. He didn't even mail it. And that's why I brought out one motion to challenge the jurisdiction of the court to allow such behavior to take place. But I went down there to the clerk and I purchased a copy of that final judgment, wherein I found out all the fraudulently altered additions and deletions, even incorporating a billing that I put in against all these plaintiffs for their corrupt acts and actions. that they were taking against me. And so what Mr. Smith here, the chief attorney there of the city of Abilene, is doing is just trying to confuse the judge. And I only say that because maybe other judges may have been honestly erring in what they do. But this judge, Lee Hamilton, the man, acting as a corrupt judge, knew exactly what was going on and defending the plaintiff so that they wouldn't have to pay. From what I understand, where you got a courthouse within the city limit, the courthouse is normally rented from the city. They might pay $10 a year, whatever they do. So there's this conflict of interest right from the start. Anytime a judge that's business is set up on a city property, paying very low rent, has when somebody comes in against their landlord. But this is America. So furthering, Mr. Smith was saying, Your Honor, and then he's filed this motion to challenge jurisdiction in July of 2009, some 2.5 years later after the final judgment. And the reason I did was because I got the letter showing that their cause of action was a fairy tale, and I could file a challenge to jurisdiction at any time, my friend. And until the court proves it has jurisdiction, everything is frozen. So this here hearing shouldn't have taken place, but you'll see some of the wickedness of this Mr. Smith trying to dodge what's headed his way. It's still headed his way. He says quickly, Your Honor, under Rule 329B, under the Rules of Civil Procedure, it talks about the time for filing motions. And specifically, it talks about filing motions to modify, correct, or reform judgment. And from the motion to challenge jurisdiction he filed on July 10th, 2009, it appears to me that he's asking the court to vacate the final judgment that was previously entered and find the court had no jurisdiction. I'm reading between the lines in his motion, Your Honor. I don't know if that's what he's exactly asking for, but I'm reading between the lines. And today he's making arguments that there was insufficient evidence for the final judgment to be rendered in the first place, Your Honor, which I guess could be considered a motion for new trial. I guess it could be considered that, but under Rule 329B, it talks about a motion for new trial. If filed, it shall be prior to or written 30 days after the judgment or other order complained of is signed. Well, I'm not going that route. I don't want a new trial. The trial should have never taken place. The 10 plaintiffs should have never filed known frauds in a court against me. And the judge, knowing about it, thinking they'd get away with it, actually thought they was going to murder me, but I escaped. I fled to New York. But furthering, Mr. Smith says, and 329B talks about a motion to modify, correct, or reform a judgment. Also has to be filed within 30 days, and Part D talks about a trial court has plenary power to grant a new trial or vacate, modify, or correct a judgment within 30 days after the judgment is signed, Your Honor. Obviously, the 30 days has passed. Even if the document that he filed within the 30-day period was considered a request for a new trial, there was no order granting a new trial. And that rule talks, if there's no order signed within 75 days, then it's considered overruled by operation of law, and then the appellate period begins to run. Your Honor, and it's my understanding there was no appeal taken in this case to the appeals court. It appeals to me that the respondent is arguing an appellate issue before this court today, that there was insufficient evidence for the final judgment to be rendered, which, the court has no plenary power to vacate its prior judgment. It has no plenary power to issue a new trial. It has no power to hear an appeal, Your Honor. And I also think he argued about an open records request. That's not within the jurisdiction of this court as well. But that was 2007, Your Honor. That's the first I've heard of. I think that's when Mr. Smith got hired after the plaintiffs started resigning and fleeing. So I don't believe that the court has any power, even if the court wanted to vacate the judgment, even if the court wanted a new trial, even if the court wanted to grant what the respondent is asking for. I don't believe that the rules of civil procedure and state law allows this court to do anything at this point, Your Honor. Under this motion that he's filed, and the argument he's made. So I believe that the court's hands are basically tied under the law, Your Honor. The second argument I would make is under Rule 329B. It talks about the time period has lapsed for a motion for a new trial or a motion to vacate the judgment or reform the judgment, that the respondent can file a bill of review, and I don't believe that even in the motions that are filed, and even in the argument today, I don't believe he's argued anything that would show this court that he has a materious allegation bill of review. And I have a Supreme Court case that sets out the requirements for a bill of review, if I could present to the court, Your Honor. And the court says, please. And I'm sitting there, my head's swimming. I'm like, what bill of review? I didn't submit no bill for review to anyone except for those who were owing. So here Mr. Smith handing to the judge and to me. And the judge said, what does this case stand for? Smith says, Your Honor, this is a case, Baker versus Goldsmith, which is a 1979 case, and it basically sets out what the complaint has to show to have a bill of review granted in the trial court after the plenary power is passed. And you can see here, my friends, says Mr. Hawkins, and I stated, Your Honor, I have to object. I didn't put in no bill of review. I don't know why he would even be bringing this up when there's no bill of review that I filed. And the judge says, response, Mr. Smith. Mr. Smith says, well, Your Honor, for what he filed, I really couldn't tell what he was filing. So I just wanted to address all the issues with the court. The court says, okay, you may continue, Mr. Smith. So Mr. Smith says, thank you, Your Honor. It says in order to be successful upon a bill of review, the complaint must allege and prove material. And this fellow's such a hypocrite in what he reads here, because they didn't have to prove their cause of action. And if I did file for a bill of review, it says I have to prove it. Well, why? They don't have to prove that 600 Virgil existed. They used your tax dollars as evidence to show that they just don't care, you know. Excitement to the delinquency of these people that are time and time again shown to have broken the laws, and yet public servants using those broken laws against others. So Mr. Smith says, thank you, Your Honor. It says in order to be successful upon a bill of review, the complaint must allege and prove a materious defense to the cause of action alleged to support the judgment, which I don't believe he's alleged or proven that he had a materious defense. And of course I said, and it was actually an objection. I say objection, Your Honor. I never even put in for one. And then Mr. Smith says, secondly, Your Honor, he has to allege and prove that he was prevented from making that defense by fraud or accident or wrongful act or wrongful act of the opposite party. And I believe all the arguments that he's made today is all evidence that he was aware of and that occurred prior to the final judgment being entered, that Mr. Smith didn't send to me at all, against court rules, trying to keep me from the time limitations, but I did buy a copy of that fraudulent judgment, and I filed a challenge to jurisdiction against it before the plenary powers ran out. Furthering, Mr. Smith says, so I don't believe that there was any fraud or accident that he can really rely upon that would show that he was prevented from presenting any defense, Your Honor. And thirdly, it says that it has to be unmixed with any fault or negligence of his own, Your Honor. And I believe if Mr. Hawkins was aware of all these alleged frauds that he's claiming today, and he was aware of the right to seek an order about jurisdiction, he is aware of all these things prior to the final judgment being entered, and I believe he even testified, and you see right here, I testified today, my friends. Mr. Smith even said so, and I believe he even testified today. He made the decision to put everything on hold and seek remedy through the Attorney General, and I said, no. Mr. Smith says, Your Honor, and I said, I object, Your Honor. That's not what I stated at all. Court says, response? Mr. Smith says, I believe that's what he stated, Your Honor. He made the decision to review. And the court says, the court recalls what's been stated. Please continue, Mr. Smith. So Mr. Smith says, thank you, Your Honor. Under all these, I don't believe he's met any of these 3 steps for a bill of review, Your Honor, and that the court has no power to grant a bill of review and has no power to vacate or reform the final judgment that was entered 2.5 years ago, Your Honor. And I speak up, as I do, and I said, well, I agree with all that, Your Honor, because I didn't put in for a review. A bill? What? We're talking apples and oranges here. That has absolutely nothing to do with anything. That's the pleadings before the court today or at any time. I've never done that. So why would he bring this up in court to further deceive or cloud the issues? And the judge says, thank you, Mr. Hawk. And I said, you're welcome, sir. And the court says, okay, I signed the final judgment and order in this case, November 28th, 2006. I no longer have plenary power over this case. And I said, I object, Your Honor. You do have, because, and the court says, and I said I objected to the jurisdiction of this court, and the court says, and I interrupted again and said, and that froze all plenary powers. And the judge says, as I said, I have no plenary. I have no plenary power in this matter. Why? Because he's a chief conspirator and he's been found out. The judge finishes here. He says, as I said, I have no plenary. I have no plenary power in this matter. And Mr. Smith, if you'll prepare a finding and order for my signature and send it to me, I would like for you to simultaneously send a copy of your proposed order to Mr. Hawkins, and I will hold your proposed order for 7 days. If there's no objection to form, I will sign the order. And as you see, we are in recess today, so no, court wasn't over. It wasn't through. There's a challenge to jurisdiction filed. It is still open. Everything is frozen solid right now, and we're just waiting for America to do the right thing and to investigate this matter fully. And then the judge finishes saying, and we are in recess today. Thank you very much. Proceedings adjourned. And that was at 4:01 p.m. And then, of course, you see down here on page 31, Julie R. Campbell again writing a affidavit to show that there are false things taken out and things added to transcripts. Please read the transcripts when you do get them, my friends, if you can afford them. I think this one here cost me like $450. But you can see this is the state of Texas, county of Taylor. This is an affidavit. I, Julie R. Campbell, a certified shorthand reporter in and for the state of Texas, do hereby certify that the above and foregoing contains a true and correct transcription of all the proceedings had in the above styled and numbered cause, all of which occurred in open court, and then, she says, deceptively here, or in chambers, and were reported to me. That's a nice way of saying that whatever is shown in the transcripts of the judge, if he don't like it too much, he can change it, modify it. But I didn't give him much to modify in there, my friends. It pulled the cover off this viper's den filled with domestic terrorists, and if they've done this to me, they'll do it to you, or in chambers and were reported to me. I further certify this transcription of the record of the proceedings truly and correctly reflects the exhibits, if any, offered by the respective parties. Witness my hand this 9th day of September 2009, so on and so forth. And that was the end of these transcripts, my friend. Have you ever watched a television show, my friend, where courts ever acted in such a way as this? Well, I know most Americans, they watch a show on Law and Order, and what do they believe? Well, they believe that there's justice in America because it shows it on television. So, my friends, please, if you agree that something has to be done, then it's up to you, my friends. The USC, Title 18, subsection 4, felony of misprison. I am leaving a bunch of email addresses in the description of this video. Please copy and paste all of those addresses all at once and stick it right into your to window of your email. Send this out to all those individuals. Find some for yourself. Find out who your state representative is, or your state representatives are, and they've got it a clever way now, my friends. It's hard to find an email for anybody. I've been searching a long time gathering the list I have, as most of these individuals will make you put in your zip code and then the last 4 digits to find out if they even got to listen to you. So you send these to them anyway and keep track of the emails you get answered. I've never had any answered except one by Jay Leno. Of course, I had a couple with the appellate court wanting me to file, but as stated, I've written the Judiciary Committee, against the judges. They always rule in the judge's favor. I've written the bar against these attorneys filing known frauds into court cases and such, but they're doing all right. It's the foxes guarding the hen coops, the chicken coop, and we need to take care of the fox. And you can help by just copying and pasting all those email addresses, put it right up there in the to who you're going to send this email out to. Sit back, relax, and know that you done your best, because there's not many other avenues you can even use, my friends, from what I see, especially if you're a whistleblower, to get any protection whatsoever from the wicked and evil public servants that come after you when their kingdom is threatened. As Ronald McDonald, we'll get to the bottom of this, my friends. We'll clean the carpets first, and then we'll go to the ceilings. And with that, do know that I do love y'all. I pray for y'all every single day. And I do not commit suicide. If I was allowed suicide within my faith and my belief of what the scriptures say, I would not have made this video. I'd already be decomposing. Those that investigate this file, you're going to see I'm a real composer. So bye, everybody, and sleep well.